So for those of you who don't know me, my name is Bill Schrom. I'm currently the sheriff of the Schrom County Sheriff's Office. I'm just finishing up my 30th year with the Sheriff's Office. Spent my whole career with them. Started out as a road patrol deputy, worked as a criminal investigator for about 11 and a half of my years, was the undersheriff for about 13 years, and became acting sheriff last year, and then ran in the election in my official capacity now. So I know in the past, a lot of the talks have focused around the SAFE Act, and we thought we'd change it up a little bit this year because of the new bail reform and discovery laws seem to be a very hot topic. I'll be very honest with you. Even for law enforcement, we're still learning a lot about them because this was pushed through very similar to the SAFE Act. It was pushed through very quickly, and law enforcement is still navigating their way around it and trying to get a good handle. But we are seeing some of the impacts, and that's really what I wanted to focus on today. And then certainly we'll open up any questions about anything afterwards. So the bail reform law, it's also known as the Bail Elimination Act of 2019, more affectionately by law enforcement as the Catch and Release Program. We are seeing these criminals being arrested for a variety of charges and immediately put back out on the street. So, like anything, we have our own terms for different things. So, the new law prohibits arraignment judges from demanding bail for certain defendants or remanding them to jail. So, arraignment judges are simply judges who the defendant makes their initial court appearance in front of. So even if somebody's arrested for a felony, and that case will ultimately end up in county court, they are initially arraigned in front of a local magistrate. So they might go to a town court for their initial arraignment, and then it's referred to county court. Instead, they must release the defendant on his or her own recognizance. The new laws prohibit judges from imposing cash bail on defendants accused of misdemeanor offenses and nonviolent felonies. And I purposely highlighted the term nonviolent because some of the examples I'm going to give you, I think will make you scratch your head and how it does not qualify as a violent crime. Just to familiarize, and I'm not going to talk to you as if you don't know, but I'm going to talk to you as if you don't know. So I'll explain some of the terms just so you have a complete understanding. A misdemeanor is any offense that's punishable by up to a year in jail and or a $1,000 fine. So it can be a DWI, petty larceny, certain harassment, simple assaults, those types of things. These are punishable by up to a year in jail and or a $1,000 fine. Instead, these defendants must be ROR'd and instructed to return to court. Bail will remain an option for defendants accused of violent crimes. So first of all, they're not going to send them to jail. Second of all, they're going to advise them, hey, you have to come back to jail. And if you don't worry about it. We'll call you, we'll text you, we'll send you a gift card to make sure you come back. I'm being a little facetious, but I'm just trying to emphasize my point. And the option, I do know how well it works, but I just work it off on the screen. The option for defendants who are accused of violent crimes. So even if it is a violent crime, the judge can still choose not to impose a bail. So what's important to understand about bail is not meant to be punitive. Bail is to simply ensure that the person accused has an incentive to come back to court. Because if they don't, then they're faced with...
How do our local judges do this?
I'm sorry?
How do our local judges will risk? How does he feel about, at his discretion? I mean,
puts a lot of pressure on it.
It does. So I think his question is, how do the local judges dealing with this, and what are the thoughts about it? I think the judges, law enforcement, your attorneys, except for the defense attorneys, are all on the same page. They scratch their head about these laws. I think the judges somewhat feel boxed in that they have to comply to a certain extent. I think most of them apply good reason and rationale. If it's a violent offense, they're going to make sure that somebody's held accountable and put in. How long they stay in, it's really not incumbent upon them. They can only post a reasonable bail, But if the person comes up with bail, they can't keep them in there above and beyond that. So if that makes sense to you. Under this new law, there are over 400 crimes that will require mandatory release. This is not an option. Over 400 crimes that the judges will have no say in and that they have to release the defendant. So what I did was I gave you my top 25. I went through this and picked out 25 out of the 400 that should have everybody shaking their head or scratching their head. The following are just a few examples of crimes that will require the release of a defendant without bail. Burglary second and third. What differentiates burglary second and third? Burglary is defined as entering or remaining in a building or dwelling with the intent to commit a crime therein. If it's a dwelling, they're talking about your home. That's burglary second. It's the more serious of the two. A burglary second is considered a Class C violent felony in New York State, by definition. But they're only releasing non-violent felons. But here's one that they're releasing, so it's an oxymoron. Burglary second means you're in your home, you're sleeping, somebody breaks into your home, steals your property, leaves, gets caught later with your property and or confesses to the crime, they're released right back out. And if you marry that example into the discovery laws, which we'll talk about at the far end of this, the other end of this presentation, essentially what the discovery law is going to allow is not only was the person who broke into your home released after they were caught, now they're allowed to come back into your home with their defense attorney to prepare their defense for trial. To me, that's re-victimizing somebody. There's nothing more personal than somebody coming into your home. Most residential burglaries do occur during the day. The reason for that is because people are generally not home during the day. Most people work. That's when you see most of your business or your residential burglaries. Your business burglaries, of course, they occur at nighttime when the businesses are closed. That's burglary third. Robbery second and third degree. Robbery is defined as the forcible stealing of someone else's property. Forcible stealing generally implies violence. That's me physically harming this man or threatening him with a dangerous or deadly instrument and taking his property from him. I don't understand how that's a non-violent felony. Criminal sale of a controlled substance first through fifth degrees. That doesn't mean I'm just possessing narcotics. That means I'm selling them. I'm distributing them to other people, minors, whoever. Use of a child to commit a controlled substance offense. Reckless assault of a child by a daycare provider, and reckless assault of a child. So apparently, if you assault a child, that's all right. We want to let you go back out on the streets. These things should have every one of us shaking our heads to say, who even came up with this? It's ridiculous. Stalking, first through fourth degree, to include while committing a sex offense. So stalking generally means that you're creeping around, you're peeping in somebody's window, watching them, you're following around in a public area, which is very intimidating and threatening if you're the source of that person being stalked. But you know what? If you get caught for it, we're going to let you right back out. Because we know that's going to make the victim feel that much better, that this person was held accountable. Vehicular assault means that you're using your vehicle to cause injury to another person. Aggravated assault upon a person less than 11 years old. I don't even know what to say to some of these.
What if he's 12?
Yeah, right.
I mean,
Criminal obstruction of breathing or blood circulation, and that is actually a new part of the law under the harassment section that came in a few years ago. And generally what prompted that a lot was the domestic abuse cases that we were investigating. You would have somebody get into an altercation and the spouse would choke, either strangle or just choke out the person in the home. But now if they do that, they'll be arrested, but they'll be immediately released. So now if you're the victim that was choked unconscious, now you've got to worry about that person coming right back out and coming back to you. And certainly in most of these cases, there's going to be what's called an order of protection issued on behalf of the victim. But what we need to remember, that's just a piece of paper telling somebody to stay away from somebody else. It's enforceable, certainly through the laws called criminal contempt, where you can actually charge somebody for violating that. But again, that's going to be after the fact. You're going to be reactive to that problem. Where are we? Criminally negligent homicide, vehicular manslaughter, arson 3rd through 5th degree by fire or explosion. So you can burn somebody's building or whatever down or blow it up or whatever, but we're going to release you. This is just, all right, bail reform is the title here. But if you jump bail in the 1st or 3rd degree, we're still going to release you. It's absurd if you think about that. Obstructing governmental duties by means of a bomb.
Oh my.
Escape 1st through 3rd. So you do catch me, for whatever reason, I do get put in jail. I say, yeah, I'm going to escape. We're going to turn around and release you. I don't know. And you can look up any of these yourself. Again, this is just 25 examples of over 400 that we have. Resisting arrest, which we see quite often. Generally when law enforcement arrests with somebody, if they're under the influence of drugs or alcohol, they're generally non-compliant. Last thing they want to do is be put in handcuffs, so they oftentimes will fight with the police. When that happens, now we have to turn around and release them. Most sex trafficking, not all, but most. Disseminating indecent materials to minors, endangering the welfare of a child, endangering the welfare of an incompetent or physically disabled person, promoting, possessing an obscene sexual performance by a child, promoting, possessing sexual performance by a child. Did I have that in it twice? No, one's obscene, one's not. And I tried to look up the definition. I did actually look up the penal law last night, and to be honest with you, I can't recall what differentiates the two. Unlawfully fleeing from a police officer in a motor vehicle, which essentially says if they take off on you in pursuit and you opt to chase them, regardless of how that pursuit ends up, even if they were to crash their car and hurt or kill somebody, they would still be released. So is it really worth law enforcement, one, risking themselves and putting the public at risk? And that's pursuits are very controversial to begin with, just because of the potential negativity that comes with these. So now I think you're going to see more and more law enforcement agencies backing off, even wanting to do it. So how has this impacted law enforcement? I can say, from the uniqueness of a sheriff's office, which is it's unique from any other law enforcement agency for a variety of reasons. Number one is the sheriff is elected by the people. They are not appointed by city council or a mayor. We have the responsibility of a county jail and a civil division. So one positive impact is they predicted anywhere between a 40 and 60% reduction in inmate population once the bail reform went into place. Our facility houses a maximum of 264 inmates at any one time. That's the most that we can house the way we're currently staffed. If we have a capacity that goes beyond that, we can get a variance from the New York State Commission of Corrections to house additional people, but we have to have more staff to accommodate that. I think in the 30 years I've been with the sheriff's office and the 14 or 15 years I've been under sheriff's role, I've only seen it once, and that was about 2006. I think we were around 270-ish. It was just, we were packed to the hill. It's the only time we had to ask for a variance to accommodate that capacity. We also have the uniqueness of a jail. We house both male and female inmates. So just to educate you a little bit on it, not to get too far off the topic, but, oh boy.
That's what I'd have done.
I have no idea why they said that. Somebody killed our power somehow.
Oh, really?
Nothing?
Nothing.
Oh, you know what? I wonder if they did. Okay, what I was saying. The uniquenesses of the sheriff's office. So not only do we have male and female inmates, if we have a housing unit that houses all female inmates, we can have a male officer actually work that post. There's nothing wrong with a male officer working an all-female post. Our biggest housing unit houses up to 60 male inmates at any one time, and it's a dormitory setting. We have females that work those particular posts. There's nothing that precludes them from doing it. The law recognizes a correction officer is a correction officer is a correction officer. So they can bid any post they want. The only time it becomes gender specific is if that person is on what's called constant watch. That means they're on one-on-one observation for a period of time. Generally it's because they've threatened to harm themselves or they've actually attempted to harm themselves. So for that reason, if she's in a cell, my job is to watch her for my entire 8-hour shift. So I'm sitting outside of her cell on the other side of the bars in a chair watching her for 8 hours. So we all know what's in a jail cell. A bed, a sink, a toilet, and a small desk.
See the
Maybe it'll come
TV's
up.
not on though, you gotta turn the TV back on. Gotta be a button. All I see is a red light.
there's a red light on it.
Yeah, the red light have all on the power switches. It just says menu, source.
Where's the circle with the line through it? There you
There it
go.
goes.
You going?
There you go. Did something.
Got blue light.
So during that entire shift, if that person has to go to the bathroom, they're doing it in front of the officer. If that inmate has to shower, they're doing it in front of the officer. So for those reasons, that's the only time it has to be gender specific. There we go. Perfect. So in 2019, although we can house up to a maximum of 264 inmates, our maximum, or our daily average population last year was only 135 inmates, which is significantly low. Certainly makes it easier for us because it's less headaches and it's a little bit easier to manage. This year, our daily average population is hovering right around 90. As of today, are you kidding me?
Yeah.
So as of today, we have 87 inmates in our jail. 15 females, no, we have 97, I'm sorry. 82 males, 15 females. So our population's pretty low. What prevents us from, so we have 8 housing units total. We've been able to close 3 of those. What that allows us to do is disperse our personnel to cover other things. We have issues with abuse of FMLA, which is Family Medical Leave Act, abuse of sick time, people who are on 207C, which means they're so we're allowed to disperse personnel, yes.
So question. So if they come before a judge and they get released on release,
Yep.
how many times can they come before the judge? Like how many times do they get released?
So that's a great question. She's asking if they went in front of a judge, how many times, if they don't come back. I've heard different numbers, like 2 or 3 times. They get these chances to come back 2 or 3 different times.
When is it cut off?
I don't know if it's when the judge finally gets sick of it and says enough's enough. You've been given more than your fair share of opportunities. I think it's discretionary upon the judge. We don't dictate that. But unfortunately, who's going to go down and track the person down on the warrant? It's going to be the police. That's going to be their job. So. So currently our population is reduced about 33%, a little bit under what they projected, which is still in the ballpark. It's not a horrible thing because I can tell you, the correctional facility is very unique in itself. In that, and what even separates a county jail, in my opinion, from a state facility, is every single inmate that comes in. Not every single inmate, but a percentage of the inmates that come into a county jail are essentially a train wreck. They're the ones that are right now going through the withdrawal process from heroin or opioid addiction. struggling with withdrawal symptoms from their alcohol. When they're ready to go to the state, if they go to the state corrections facility, they've all been treated. They've all been triaged like MASH. Now they're ready to move on. So, you know, that's definitely one of the uniquenesses to it. And one of the downsides of the bail reform is we have what's called Operation HOPE, Heroin Opioid Prevention Education. We do it in the public to educate the public, and we also do it within our jail to identify inmates who come into our facility that have heroin or opioid or other types of addiction or dependencies. What we're able to do is immediately put them with our medical staff, do an assessment on them, and get them on a treatment program. With the bail reform, these people that have those addictions, they're coming in, they're turning right around, they're going back out on the street. We've had people come up to us and other sheriffs and said, if it hadn't have been for me going to jail, I would have never gotten sober. I would have never turned my life around. Because if anybody's familiar with anything to do with addiction, if you put them right back in that environment, they're never going to break that cycle. This can actually be an opportunity for them to do that. And unfortunately, in here they can't. So that's really too bad. I really apologize for this one. It seemed to work for the other guy fine.
It's the bottom button. Do you think it's fair to say that there's a motive behind this in increasing crime statistics so that there can be more laws restricting law-abiding citizens in the future?
Boy, it's hard to say motive unless somebody gives it up, you know what I mean, and says it to their true intent. I mean, you can presume.
Wouldn't it look? It looks that way though, doesn't it?
Certainly can make you wonder. Absolutely
Okay.
can make you scratch your head. So let's see. Oh, the only other thing I want to say is, although we've been very proactive to close the housing units if we can, we're somewhat limited because we have two different types of inmates that come into our facility. They're called close confinement inmates or general housing inmates. And really what differentiates the two terms is the nature of the crimes that they're in for. So our more serious offenders, they're considered close confinement. They're housed totally separate from the person that comes in on a petty larceny, a DWI, some type of minor offense. If we were to start to mingle them, it's going to be a nightmare. Because usually your hardcore inmates are going to prey on the people that are a little bit softer, maybe not as in tune with the styles of a jail. So we were forced to keep them separate, and it certainly makes sense. And this just kind of gives you an idea of what's happened real quick. In 2019, we had budgeted $575,000 just for overtime in our jail. People are like, wow, that's a lot of money. We actually asked for more, and they only gave us $575,000. We finished at $781,000. That's 36% over budget. That's unacceptable from an administrative standpoint, and as you as a taxpayer saying, wow, we got a problem. You're not managing your facility correctly, or there's other issues that are contributing to this. So far in 2020, our overtime has dropped dramatically, and this is in part contributed to the new bail reform because we have less inmates. We can close down posts, and we can disperse personnel to cover some of the other problems we're having with crime and abuse. Another big contributing factor is when we had put in for the overtime for 2019, the contract for the correction officers had not yet been ratified. And once it was ratified, they end up getting 11% raise over the period of their contract. So now that overtime rate is calculated at a higher number. So it just gives you an explanation and understanding as to why it happened. And then again, we had issues with 207C, family, that kind of stuff. All right, I'm going to transition into the discovery law, also known as the blindfold law. And I think that's because some of these laws were pushed through and they just didn't take the time to look at how it was going to impact us long term. It became effective January 1st. There were new requirements to the discovery material regarding all criminal arrests. Defense attorneys are now entitled to all completed paperwork to include reports, search warrants, lab results, and etc. as soon as practical, but no later than 15 days after arraignment. So that might not mean a lot to you, but if I am arrested on the street for a serious charge, once I make my initial appearance in front of that judge, which can be the very same night I'm arrested, that clock starts ticking. Now the law enforcement agency has to compile all of their information, all of their case information against this defendant within 15 days to get it to the defense attorney, to include all the information on any witnesses, their name, their address. There's something else here. I don't know if it's in the slide or not. Not only does the defense attorney have privy to, but the person who was arrested also has that information. In cases where lab results were not yet available, this will be communicated to the defense attorney through the district attorney's office. So I think there are special circumstances that will span that 15 days up to 30, a maximum of 45 days. But still, to be quite honest with you, as a former investigator, as a former supervisor, everybody who does a report has to complete that report. It has to go to the supervisor to be reviewed to make sure it's correct and adequate. If there's any corrections, it's got to go back to that officer for those changes before it comes back to the supervisor for the final sign off and before the package is sent off to the DA's office. That's a lot of things that have to happen in a short period of time to meet these requirements. Let's see, this is placed a significant burden on our personnel to ensure that all case reports are completed, reviewed, returned for corrections and signed off. This has even created a more burden to the district attorney's office in complying with these new discovery demands. So, from my perspective, I've got to worry about me and maybe the guys that work for me. But in Schrom County alone, we have 6 different law enforcement agencies. Schrom County Sheriff's Office, New York State Police, Elmira Police Department, Elmira Heights Police Department, Village of Elmira, or Village of Fort Saints, and West Elmira. That's 6 different agencies that are compiling all their information, and then the conduit to the court is everything goes to the DA's office. So the district attorney's office now has 6 different law enforcement agencies pushing this paperwork to them as quick as they can. They in turn have to go through it, analyze it, and get it distributed to the defense attorneys. It's just not reasonable. It's not practical. It makes no sense. We're rushing. And when you rush, you have the much more potential for errors that you didn't plan on, shortcuts. You know, you're talking about affecting somebody's due process or liberty and rights. Keeps rushing these things through. The governor has allocated significant funds to the defense attorneys. The people are going to get all this information, but they haven't done anything to help out the district attorney's offices or the law enforcement to make sure they can do it in a timely manner. His proposed solution is to reduce the money available to county jails and relocate that money to the district attorney's office. So here's the governor's mindset. Because of the new bail reform, when I put in place as the governor, I've now reduced your inmate population substantially. Because of that, you can now lay off officers and save money. We'll take the money that you're saving in the jails around the state, and we're going to transfer that money and give a little bit more money to the district attorney's office. The problem when they don't consult with appropriate stakeholders and where the governor failed to understand what this process is all about, you do not staff a facility based on your daily population. Your facility is staffed based on its maximum capacity. So just because our population is hovered around 90 to 95 for this year, doesn't mean we're in a position now to lay off 10 correction officers. Because what happens if that pendulum starts swinging the other way and that population starts to swell again? Are we going to pull 10 COs out of our butt? No. Now we have to go through the whole process of hiring and doing backgrounds, and it is a very lengthy process. There's very poor thought put into that, and that's certainly not it's certainly not going to help it. Last year alone, just in Schrom County, there were over 17,000 tickets that were processed through the DA's office. That's just 17,000 traffic tickets. That's 6 different agencies writing these traffic tickets. Because of the new discovery laws, every officer that has an in-car camera and or body camera is now required to upload that data, save it in the event the person who got written a ticket decides to take it to court. That takes a tremendous amount of time. It takes a tremendous amount of space to store that. Again, a cost that's incurred on law enforcement, another unfunded mandate that we have to figure out where we're going to come up with the money and how we're going to store all this equipment or all this information in the event that it's needed. Our staff is currently spending about 2 to 3 hours each day just uploading body camera and in-car camera footage for all arrests and UTPs. I put 2 real quick examples in that just happened within the last 2 weeks. Our officers responded to a bar fight. We had 5 different officers there. Every single one of them had in-car cameras on when they pulled in the parking lot, and all of them had the body cameras on. Every single one of those officers' data, regardless of the amount of involvement they have in the arrest or dispersing the crowd, it all has to be saved, it all has to be uploaded, it all has to be available should it be needed down the road. We had a mental health issue where a person was threatening suicide. It turned into a 3.5-hour standoff. We had 4 officers there. The event lasted up like 3.5 hours. That's 3.5 hours of you recording and now have to upload that data and save it. Additionally, we're spending about an hour a day processing evidence to include videos from home or in-store surveillance. It seems to be the trend, a very good trend in my opinion, that more and more homeowners are putting in systems. There's a lot of good systems out there you can put in. Arlo's aren't very expensive. I'm not promoting, I don't work for Arlo, I'm just throwing it out there because I actually happen to have that. And I'll tell you, it's a huge tool for law enforcement to have that, because if we're investigating a scene, one of the first things we do is we go to the neighbors and knock on the door and say, by any chance, do you have surveillance cameras on your homes? Because it can be beneficial to us. Just this past week, there were over 25 requests for body camera or in-car camera footage to be uploaded and saved. Numerous requests from the DA's office for any and all footage. Our records clerk workload has increased substantially to ensure compliance with the new law. And again, this is an unfunded mandate. We don't have the personnel to keep up with the requests of discovery laws. We need more people. Who's going to give them to us? We have to advocate for the legislators. Money's tight. They can't just start throwing at people and say, yeah, all right, here, hire 5 new people. It'd be great if they did, but sooner or later, something's going to have to give. One of the very scary trends, from my personal opinion, is we're seeing a lot of law enforcement agencies that are now saying, you know what, we're not going to use our body cameras anymore, and we're not going to use our in-car cameras anymore. That's a very scary thing on a lot of different levels.
Yeah.
In our office, we instituted the body cameras on the road patrol initiative. I pushed very hard as the undersheriff at the time to expand the body cameras into our jail. The reason I did that is because we're receiving numerous grievances from our inmates, basically saying, Officer so-and-so mistreated me, Officer so-and-so said this to me, Officer so-and-so used excessive force. We implemented body cameras in the jail, those grievances literally disappeared. So that told me one of 2 things. Our officers changed their behavior in the manner in which they were interacting with the inmates, or the inmates knew that they could no longer make up false allegations against the officers. I'd like to think it was the latter, but to be perfectly honest with you, I could care less. I know that the problem is rectified.
Right.
It's gone away. If we now are afraid and worried about the amount of time and money we're going to have to put into all this data and the time, to upload it and all that stuff, and stop using it, we're going to open ourselves right back up to that. 2, it's an officer safety issue. If you take the uniqueness of a deputy sheriff and a New York State trooper, our job is to patrol the rural parts of a county where our backup isn't 2 or 3 minutes away. If I'm in Venetton at a hot domestic or a bar fight, if things turn bad, even if my backup is coming lights and sirens, it could be anywhere from 15 to 20 minutes or longer. Lights and sirens for my backup to get there. So 1, it's going to alter my approach. But 2, if I have a body camera on or an in-car camera, even if something bad were to happen to me, it's recorded. There's value to that. So it's very scary, and I understand why a lot of agencies are doing this and backing off, because I know locally it's happening right now. My position is not to do that. We'll fight through and figure out a way to comply, but I just think there's too much value in keeping that. The timeline of compliance simply is not reasonable. The confidentiality of informants, the safeguarding of witnesses, and the privacy of citizens unrelated to the case, but somehow identified in the materials, will be at risk. That's a very scary thing. These defendants are getting this information much too early. Many defendants want to find out as much about the witness as possible, not to unearth exculpatory information. And exculpatory information is information that would prove somebody innocent. That's not what they're looking for. They know that information is not going to be out there. What they're looking for is to identify a target, to intimidate a witness who possesses incriminating information. So because this witness tampering and intimidation represents a fundamental threat to the rule of law, many crimes will now go unreported because people are like, you know what? I'm not gonna turn somebody in because you're gonna tell them I was the one that did it, and now they're gonna come back after me. Witnesses will recant statements in a trial out of fear and intimidation. They're gonna back off and say, you know what? I think I was wrong. I don't think I saw it the way I saw it, and here goes the person free. This will result in harassment, intimidation, and violence against innocent citizens, witnesses, and victims. They will simply refuse to cooperate if they know that their name, address, and contact information will be given to the defendant before the trial. A lot of people in sensitive cases, their identity is protected up until the day of the trial in the event that somebody accepts a plea and they resolve it outside the courts. That way they're never revealed. That makes sense. It's common sense. It's a tactic that's been used forever. The district attorney will tell the defense attorney, I have 3 witnesses that are going to incriminate your client. If you make me reveal who they are, the plea bargain's off the table. We're going to trial and we'll see what happens. That's a heck of a tool to have. Now, we have to give it to them early on, and not in every case, but there are people that are connected to other people. Now they can reach out, seek out these people and say, hey, you're not going to testify, right? Yep, I heard that loud and clear. So, proposal to repeal the Civil Rights Law 50A. And Civil Rights Law 58 protects law enforcement and peace officers. Essentially, it means that you don't have access to our personal information and you do not have access to our personnel information. So if sometime in my career I messed up and I was disciplined for something, unless it was directly applicable to the manner in which it's in front of the court, it is not revealed. Now, under the discovery law, they're trying to make that an absolute automatic part, that they have everything about the law enforcement officer personnel-wise. So what's that? Right, and under the Freedom of Information, the FOIL laws, that's how we get out of that. We just cite the 50A because we're not obligated to comply with that portion of it. But certainly it all falls under that umbrella. Very good. The new law would regulate that all law enforcement personnel file be turned over automatically regardless. Not fair, especially if it has nothing to do with the manner in which it's front of the court. The governor's response to the cost, man hours to comply with discovery is to transfer funds from savings that will be seen in the reduced population. Again, this is what I already talked about. And both of these proposed laws were adopted as part of the New York State budget, despite having virtually nothing to do with the budget. Certainly not theirs. It's going to impact ours.
Right.
I think for that reason, and it's very similar to the SAFE Act, kind of under the cloak of darkness, and it got kind of pushed through there pretty quick. The public, maybe most legislators, were deprived of the opportunity to give effective comment and guidance on these important changes, which is an increasing common practice that you see going on. And the majority of the stakeholders, the law enforcement and the DA's office, were never contacted and said, hey, we need your input and your guys. What do you guys see could be a potential problem with this? Because had they done that, it's not saying that law enforcement is opposed to reasonable reform, but you have to have the people that are most effective to give you the best outlook on how things are going to play out, which was never done. Now they're saying, maybe it's not so good of an idea. That's it in a nutshell. So it's not the most exciting topic, but I think it's one of the hot topics that really a lot of people are asking about. We are still struggling to learn all the aspects of it because it got pushed through so quick and basically said it's coming, be ready for it, and knock yourselves out. So I don't know if you have any questions on that.
So, without very much incident, asking guys, law enforcement, not asking me any questions, just doing what he does. Department's got to be pandering for votes. Not that he needs them, he's got New York City. It's all locked up, right? So what other possible reasons can he have for doing it? Just because, just to make, and this is what I see, you're making everybody in this room more unsafe, more vulnerable. So, with that said, let's move into another topic. Have you seen in your office an uptick of people coming in for concealed weapons carrying?
Okay. So you just asked me a whole bunch of things. So first of all, part of your answer is yep, the governor's doing it because he can. Second of all, since he's got the majority in the Senate Assembly to push a lot of these things through. Third, to be honest with you, we haven't seen a huge uptick in pistol permits. They do tend to fluctuate. So usually a major event that occurs within the country will spark that. I can tell you right around election time, you will see a spike, especially if they're afraid the Democrats are going to get into office. They're just afraid that they're going to just keep continually restricting and tightening down on our rights. And it just seems to, it really seems to put a lot of fuel. But I will give you an example. Several years ago, I think it was the SAFE Act. Several of the sheriffs at the time, and I know Sheriff Moss was one of them, actually met with the governor. There was a handful of sheriffs. I think the sheriff was the president of the Sheriff's Association at the time. There's 7 or 8 of them. The governor comes into the room. And he starts off the conversation by saying, quote, "And as far as you rebel-rousing sheriffs go," and he set the tone just like that. Needless to say, the conversation didn't last long. He got up, turned around, and walked right out. There was no dialogue, there was no conversation, but he was letting them know how he felt, and basically it's going to be my way or no way.
That's one addition. What's your view on the latest push for sanctuary county here? Like it's going on everywhere. Look what's going on in Virginia. If that happens there, even in Florida, I like to call it, we'll seize that opportunity. Pull that stuff.
I was wondering who the plant was. I figured it was one of these two guys set you up, but so this push has really, I think, been prompted a lot by the SAFE Act, and I think you see that the more and more restrictions is really fueling what's going on with that. What's important to note is I don't know anybody in this room, I can almost attest to nobody in this building that was in favor of the SAFE Act at any level. Unfortunately, it is the law of the land. This has been litigated at many different levels by many different entities. And it's been held up as unconstitutional. Believe me, I'm not an expert in this area. One of the only areas I think that got turned over with the SAFE Act was the magazine capacity. That was about the only one that said, we're going to go instead of 7, we're going to pump it up again. Big victory. Having said that, as a sheriff, I have taken an oath to uphold the law. It makes it very difficult for myself or any other sheriff to be put in that position where they say, we're not going to do what we took an oath to actually do. Having said that, and I think what's important to focus on, and you can certainly read between the lines and interpret my words with the manner in which you interpret them. Law enforcement has a tremendous amount of discretion. That discretion spreads to what kind of cases, whether or not they're going to make an arrest. If I stop somebody who's driving down the road, I find them to be under the influence of alcohol, I have a choice. I can arrest that person for driving while intoxicated, or I can say, you know what, you need to call somebody and get a ride home. You know what, get in the back of my car, I'm going to take you home. I'm going to call you an Uber or a taxi. There's a lot of discretion that goes along with that. district attorney's offices have a tremendous amount of discretion on whether or not they choose to prosecute the case. So I can tell you, since the SAFE Act has been implemented, I am not aware of one arrest directly related to it, certainly not in our county. It's not something that people are actively going out looking to enforce. I can assure you that law enforcement is probably of the lowest priority. So just keep that in mind. You know, you have support, but to a certain extent, if it makes sense. I personally, myself, Bill Schrom, standing in front of you, as your sheriff if you're from the county, I would not be in favor of that. Probably not what you want to hear, but I don't want to. I just don't want to tell you what you want to hear.
Not in favor of the Second Amendment speaker, or not in favor of force and safe law.
Yes. Yeah. Well, I know. Yeah, so I think you really have to look into the nuts and bolts of that. Zach, just so you know, I got like a 10-minute late start. I apologize because the guy went like 10 or 15 minutes, so we'll go through. The red flag, probably the most important thing for you to understand about that is even if that were to occur and you're the target of the the complaint or being put on notice, to law enforcement still has to do their due diligence. Somebody calls and says, hey, Bill Schrom is actually crazy, and he's not acting right, and we think he's a threat to the neighbors themselves. Somebody still has to come to Bill Schrom, and they don't just walk in the door and say, hey, we heard you're not acting right, give us all your guns. It doesn't work that way. They still have to do their due diligence. There's still a due process that goes along with that. They have to come in and make their own assessment. And generally, they can do that in a variety of ways. So it's not just automatic. Don't be, sometimes that just gets a little misconstrued. Yeah. And I know that's a huge one in everybody's mind, for sure. Any other questions? Really appreciate your time. I hope you took something from it, and I'm around all day, so if you think of something, come find me. Hopefully you have a sub sandwich or something with you.
Thank you.